call bar number 185173 on behalf of Ms. Davis. The time set for sentencing. Mr. Davis is present out of custody, represented by counsel. This case is ready to proceed.
Yes, good afternoon, Your Honor. George Gilbert, G-I-L-B-R-T, bar number 112076, here with Mr. Davis, who's sitting to my right.
Good afternoon.
Mr. Zemmel, what is the state's recommendation? Actually, let's make sure that the record reflects that we are present for sentencing following a jury trial in which the jury found the defendant guilty of 2 charges, count 1, criminal trespass in the 2nd degree, and count 3, criminal mischief in the 3rd degree. The jury found Mr. Davis not guilty of count 2, criminal mischief in the 2nd degree. The record should also reflect that there were requests from multiple parties to record today's proceedings, both by video and still photography. I granted that request. I'll just add the same admonitions that I've added before, which is just to make sure that the recording's not distracting, and then also make sure that the audio's not picking up any confidential conversations between Mr. Davis and his counsel, Mr. Gilbert, at counsel table. Other than that, recording is just fine. So with that being said, Mr. Zemmel, what's the state's recommendation?
And just so the court knows, there are multiple representatives from the city, at least one here who would like to make a statement. Would you like to hear from the state before the representative from the city?
Yeah, let's hear from you first.
So, big picture here. Mr. Davis has, even in his own testimony, said, there's been ongoing issues at City Hall. This is not his first case or first arrest involving incident at City Hall. So this is not an isolated incident that, a mere form of punishment is going to resolve. I think we need to dig a little bit deeper. My hope with this sentence is to have a combination of some form of mental health evaluation and treatment for Mr. Davis, some amount of community service to serve as the basis of some sort of deterrent and punishment for what he did do, as well as some level of an exclusion, the language of which I think may end up turning into a conversation amongst the relevant parties. The relevant parties here, the city is not going to be asking for any jail time. So it is.
Let me ask you about that, because I want to be honest with everybody now considering jail time.
Okay.
And the reason for that is that one of the primary reasons, and I'll get everybody's viewpoint on this. I haven't made up my mind yet. But one of the things that I'm considering is that in the videos that we saw during the trial, Mr. Davis can be heard saying, what's the worst that can happen? I'll just get arrested and then booked and released 2 hours from now. Which to me indicated potentially, one way of looking at that is that he weighed the consequences of what he was doing, compared past consequences from when he had done it before to what was likely to happen on this occasion, and then made a conscious decision to engage in the conduct that he engaged in, deciding that the sanction he was likely to get wasn't going to be a deterrent to him, and wasn't essentially that big of a deal. There maybe are other ways of viewing that statement in the video, and of course I'm paraphrasing the statement that was in the video. But that's what I took away from it. So when you're saying that you're not going to ask for jail, maybe expand on that a little bit, because again, I'm considering stroke.
And it's certainly not because I don't think punishment is warranted here, and I plan to ask for a rather hefty sum of community service. And it was my thought that having over an extended period of time to be physically doing something, physically accomplishing that community service might serve as a larger deterrent and a larger punishment than being in jail and getting that time done, so to speak. I think in this particular case, community service, particularly with the amount I'll be asking for, may accomplish more of that punishment purpose, but my statement was not meant to imply that some period of jail, I'm not asking the court not to impose that. but am more trying to focus on a punishment that would be effective and productive for both the city and his mental health. And so to the extent that the court, in addition to community service, and we'll be asking for 120 hours, in addition to that, would consider jail, the state definitely thinks that would be appropriate, but as far as the balance between jail and community service, it would not be the state's preference for it to be, 20 hours of community service and a larger sum of jail. We'd sooner see more of that community service compared to the jail, to the extent that they balance with each other. And another reason for that is when we get to the exclusion from City Hall, I certainly think for the time being at least that a full-on exclusion from City Hall is appropriate. But I do think that it's worth us having a conversation if Mr. Davis does complete a mental health evaluation and treatment, or is at least engaged in that treatment to some extent, and has completed all of his community service, having a potential opportunity to earn his way back into City Hall. And then if he does earn that opportunity back, he would still be restricted by language I propose is immediately vacate if asked to leave by anybody in charge or even anybody from G4S or the city. And what that would do is, if he isn't obeying the rules or is refusing to leave, we're not coming back and doing another full trial. This is turning into, a probation violation situation where the court could then say, okay, you've lost your privilege, you're not going back to City Hall, you're excluded, or sanctioned with additional jail or community service. But the end goal, I'm hoping, is to create a relationship between the city and Mr. Davis where, Mr. Davis can be there, but is going to participate lawfully and appropriately and not cause a disruption. And that seems to be that's the best possible result, I think, that could come here. I think when a representative from the city comes, they may be asking for a no entry for the totality of the time of the bench probation.
And how much bench probation are you asking for?
The state's asking for 3 years, and our request on the length has less to do with the severity and more with, in order to fulfill the purpose of the sentence that the state is proposing, it needs to be for a longer period of time. A short bench probation where he could say wait a year and then he's back at City Hall doing whatever he wants, I don't think is as effective of that longer period of time with just more minimal restrictions as to what he should be doing.
And then complete exclusion from City Hall as a condition of probation, is that constitutional, or do that?
I'm not aware of what would make it unconstitutional, because the basis of the exclusion is his disruption, and he's had this is the procedural vehicle for him to challenge that. So he has the procedural basis to say, hey, that's not fair based on what happened, and the court can say, I'm listening to you, you're being heard, you're challenging that exclusion, but I think it's lawful because it's based on a disruption is appropriate given the circumstances.
Anything else?
No, that's it.
Thank you, Mr. Zengel. And then I think you said that you had somebody who wanted to speak with regard to sentencing from City Hall.
Yes.
That's great. Excellent.
Is there anything else?
Yeah.
In addition to what the district attorney Simmel mentioned, I would like to also add that he be not allowed to follow city employees once we leave the workplace, either G4S security and our city employees, as we're leaving or coming through the workplace, going home. That he should not be allowed to follow us, film us, question us, because it's pretty intimidating and it's pretty frightening. And that happens frequently.
So So would that be a condition that would be worded something along the lines of no following city employees after leaving City Hall?
Correct.
Okay.
Either walking to City Hall or leaving City Hall, and to include the security, G4S security. I just in agreement with the 3 years to 5 years. I really am interested in, because of the first person or the people that he meets when he enters City Hall is G4S. If there is a concern with this PTSD, supplemental PTSD, that every time he sees G4S, it elevates his anxiety. If that's the case, then either passing through the G4S security enter City Hall, he's already anxious, and that anxiety is elevated as he's seeing G4S security as they're constantly patrolling City Hall. They're all over the place, and so if that elevates his anxiety, or becomes disruptive, then why even enter City Hall?
And then what are, if you have any viewpoints on this, it's fine if you don't. But, I'm essentially weighing the costs and benefits of two options. One option is something similar to what the state has suggested, and the other being something that I alluded to before, which is someone out of jail. I'm gonna hear from everybody about what they think about this. If it were jail, that's all it would be. It would just be jail. It wouldn't be any period of supervision or anything like that. Because I also need to keep in mind that the two offenses for which Mr. Davis was convicted are both Class C misdemeanors, so only maximums of 30 days of jail on those. So, I don't know, do you have any thoughts on?
I tend to agree with the district attorney in the longevity of the probation and then the community service in conjunction with that. If he is not allowed to enter City Hall, whether that's legal or not. Because of the self-proclaimed issues that he has when he enters City Hall, the business needs for him to be in City Hall. If there's no business moving, why? It's a business, it's a city business. Jail time, if that's the only thing that the court can offer, then after 30 days, then we're back to square one. And so I think that there is a behavioral change that needs to happen here. And I think a combination of certain sanctions, including while he's on probation, over a protracted period of time will help, hopefully, with his mental health, getting some mental health therapy or mental health help would be more beneficial than 30 days of jail. Thank you.
Mr. Samuel, were there any other individuals who wish to address the court regarding sentencing?
No, that's it, Judge.
Right, I think there's someone back there. Are you something that works for the city?
No, I'm not.
Okay, I'll give you a chance to know before that happens. Would there be comments on behalf of Mr. Davis?
Yes.
Okay, so we'll wait until the appropriate time for that.
Here until you become a disruption and if necessary,
Mr.
I will call
Gold.
the police and have you
Thank you,
removed.
Judge.
So you are
So,
welcome to be here.
In
and
a
I
way,
encourage you
these
to.
charges are
Putting your
run of
hands
the
there does
mill,
not disrupt anything. Don't
Class
want
C
to
misdemeanors, but there's
I
nothing
will
run
be
of the mill
paying
about
attention
this
to you
case.
and then I will
And
have
so
you
it's
removed.
kind of
Do you
difficult
understand me?
to
Thank you.
fashion
Don't
an
speak English.
appropriate sentence. But what I've come up with is sort
Just
of.
1 second. Ms. Zangerly, is everything okay in that?
Yes, yes, she's
Okay,
fine.
thank you. All right. Mr. Gilbert, what?
Um,
I'm sorry.
So what I've come up with is something that I think addresses the concerns about mental health and also allows some supervision, and that is basically a short period of bench probation, 1 year. We would ask for 10 days jail time. I would ask for that Mr. Davis be allowed to serve his sentence on weekends because he has a dog that he needs to care for, and that the court impose either mental health evaluation and treatment or an anger management class. And in terms of community service, I think 40 hours would be more than adequate. A little bit about Mr. Davis. He does have a mental health disorder. From what I can tell, what I've been able to verify, I spoke to his sister, Sarah Davis, who lives in Vancouver. Unfortunately, she wasn't able to make it here. She is available by phone. She told me that she does believe he has a mental health condition. She said it's been lifelong, ever since they were kids. He had behavioral problems, got into trouble, and then things got really bad when their mother died. That was particularly hard